The respondents, led by Deputy Attorney General Mwesige Rukutana, struggled to convince the 5 justices of the Constitutional Court sitting in Mbale that security agencies acted lawfully to enter Parliament and eject MPs, who Speaker Rebecca Kadaga had suspended from the House. The justices put the government lawyers to task to explain whether the situation at Parliament warranted reinforcement of the parliamentary police by the army. The justices also wondered why police detained the MPs after they were ejected from the Parliament chambers.
Is it the Inspector General of Police who instructs the army commander, or is it the army commander who instructs the Inspector General of Police?
How can they be treated like chicken thieves by recruit policemen?
My Lord, with your permission.
What we don't understand here in this country.
Was it worse than a riot in Makerere, for example? Students rioting, where the police go alone and handle. They don't call the army.
Given the number of the members of Parliament, the number of the staff of the Sergeant at Arms, and the chaos that reigned in the House on that day, it was necessary that he calls in, like he did and like the Sergeant at Arms testified, support from the security forces to assist him maintain order in the House.
The Uganda police was called to handle the situation, SFC was called to handle the situation, UPDF was called to handle the situation. Was this reasonable force? What would we do if we were invaded by another country?
Deputy Attorney General Mwesige Rukutana appealed to court that in the event that the justices agree that some provisions in the amended act were non-sustainable, they should only annul them and uphold other provisions.
That in the most unlikely event that this honorable court finds that there is anything that vitiates the will of the people, or that there are any provisions of the Constitutional Amendment Act 2017 that are not sustainable or that are incurable defective for any reason, to sever those which are not sustainable and uphold those which are not effective. We shall be making that application.
Earlier, the petitioner's lead lawyer, Mbale Dollo, urged the justices to annul the entire act if they find fault in the process of formulating and passing Rafal Majezi's private member's bail. According to Dollo, the petitioners had shown that the process of tabling and passing the Majezi bill flaunted the parliamentary rules of procedure and the Constitution.
If my Lord agree with us in respect of the process vitiating the act, then the whole act must fall by the wayside.
Counsel Elias Lukwago told court that Speaker Rebecca Kadaga smuggled the bill onto the order paper, since the Parliament Business Committee did not even discuss it, as it is provided in the law.
Members were taken to a surprise on the 26th day of September 2017, that is in paragraph 15, when the Right Honorable Speaker amended the order paper on the floor of the House to allow Honorable Majesty to bring the bill. In paragraph 17,
Lukwago also told court that the Speaker illegally suspended 6 MPs from the House sitting without giving them a fair hearing.
So the Speaker said Parliament is suspended to 2 p.m. But in the meantime, the following members are suspended. You cannot deserve honorable members of Parliament representing the people of Uganda. 6 members of Parliament with constituencies, and you just dismiss them casually like that.
I submit that, as we are going to show that there was flouting of the rules of procedure, that they vitiated the entire act.
However, the respondents told court that the parliamentary rules of procedure were followed and that the Speaker acted within her mandate to suspend the errant legislators.
Both the committee and the Parliament of Uganda conducted open, public, and accessible hearing in compliance with Rule 23 and Rule 230 of the Rules of Procedure.
That the petitioners have not brought any evidence to justify the said grievances, and their petitions do not hold water and ought to be dismissed.
Herbert Ziwa, NTV, Mbale.